Hello, YouTube. I'm Vince White. I'm an employment attorney, and we are answering publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We have a question here from YouTube user NoNo1026. I had a back in the day, back in high school, we took the SAT, and we had a friend who claimed that he had received a 1246 on the SAT. And for whatever reason, during that era in time, it was actually impossible to receive a 1246. And we, like, a person in our group knew this and then kind of like showed us all, like, hey, you can't receive a 1246. He's lying. And this has nothing to do with your username. I'm just telling a story. So we still to this day, it's been 20 years. And every time this guy gets a little braggy, a little braggadocious, we're like, yeah, man. Yeah, just like that 1246 on your SAT score, right? And he's doing very well for himself, so it's not like, I mean, it's definitely mean, but it's not like bullying, right? So I just thought that was still funny to me. It's been, I mean, I'm 40 now, and I'm still laughing. So, anyways, I think he just wanted to have a good number for his SAT, right? He's a very successful attorney now. Not in this field, though. All right, so we have a question here from NoNo1026. It was posted today on our video about quiet casing. And the question reads like so. Sir, I filed a prior EEOC case, and in it mentioned sexual harassment. But they closed it because they did not have enough proof. That doesn't make too much sense. The EEOC doesn't generally close cases. They just issue a right to sue letter. But go on. But the investigator did make them increase my pay. That also doesn't make sense. That's not a power the EEOC has. Maybe they pushed a settlement. Did you agree to a settlement in which they increased your pay? That's possible. Now that I have a second case with them, with proof of sexual harassment and proof of them ignoring me, the company said a rebuttal. The company would have put in a position statement. The rebuttal is actually your paper. If you're the employee, so you file your complaint, the employer files what's called a position statement, and then you can have a rebuttal right to the position statement. Okay, so the company put in we'll call it a position statement, denying that they knew about the events that were going on. I uploaded the first paperwork to my second case, letting the second EEOC investigator know they did have knowledge. Does that help my case? Okay, so there's a couple things going on here. In terms of proving your claim of sexual harassment in the second case, the evidence from your first case is useful as background information, but it's not proof of the events, I would think, in your second case, right? So if you're filing a sexual harassment case for the second time with different events, right? I assume it's not for the same events, so it's got to be different events, right? So different events of sexual harassment, then the evidence from your first case could be background information for the sexual harassment, but would not necessarily be evidence of the event of sexual harassment in the second case. Now, I think what you're saying here, though, if I'm reading between the lines correctly, is that you also may have a retaliation claim, right? You think they might be doing negative things to you because you filed this first case. And they're saying in their position statement, hey, we didn't even know he filed the first case, he or she, or what I did not mean to pronoun you, I apologize. So for the purposes of proving retaliation, yeah, it is absolutely valuable to put in the documentation from the first case to prove that they knew that you had complained, because then you are providing the basis for which they're retaliating against you, right? The evidence of your complaints, which are a protected activity, which would later lead to this retaliation. Now, there's a third thing that could be going on here, is they could be saying, oh, we never knew there was any sexual harassment problem. Okay? So what you're doing then, I think, in that third possibility, is you're proving, hey, they did know about this issue. I had a whole prior case with them, and you might even have had a settlement based on what you're saying here. That would also be very valuable. So I guess what I'm saying is, this sounds like a good idea in a variety of different ways, depending on what's going on. But don't skimp on your proof for the events you're alleging in your second case, right? What you're doing here is a really good idea, probably, based on these 3 scenarios. But don't let it eclipse you providing proof of the actual events that you're alleging in your second case. Okay? I hope this is helpful. I hope that you are successful and you get what you're looking for here and that you can work free from sexual harassment in the future. And if this video is helpful, like and subscribe. It does help me to help more people just like you. Take care.